You're listening to the Valley Current.
Hey, you there, David?
I'm here.
How you been?
Good. How are you?
Great. I like your whiteboard there. It shows you're pretty busy.
That's the case that I was just on a 4-hour call about. And then I got program notes over here. So see?
I love that. You know, your system alone is probably worth patenting.
Yeah.
If you could.
We'll get there. We'll get there.
Well, you probably have developed it over so many years that you've been doing this stuff because
What I'm trying to do here with this stuff in this room, this is my kid's former room, is get it closer to being a system. Because what I do currently is I just change it every time I do it a little bit. And then I go, I mean, from when you took the class, I mean, it's like light years beyond that now. And I'm like, but where's the record of this? You know? So I'm putting it together.
well, you know, we're all knowledge workers. So we keep notebooks, we keep computers,
Yeah.
we keep whiteboards. But I don't know that we systematize it. That's the part of this AI stuff that might actually be helpful, because if you think about where it's going, your recorded recollections, your recorded videos, audios, all that stuff eventually gets sucked into AI and organized, and then becomes immediately searchable and synthesizable.
Yeah.
And I don't know that it's ever going to replace a human being, but at least it's organized so that, hey, there's a legacy there, right?
Yeah. Most of my stuff is never recorded. So it's lives and dies right there. But much of it has been recorded over all these years. It's been 12 years. So there's plenty of it has been too.
Right.
So.
But without probing on the 4-hour call that you just finished, presumably on a case that you've obviously spent a lot of time thinking about, don't you do a Zoom recording or some sort of recording of that type of call?
They probably did, but I didn't do that.
Okay, because
Probably not put it all on the video here. So
no, I mean, you can't see it, but conceptually, you know, everyone can see the fact that you have a whiteboard, you have sticky notes, you have a nice slanted ceiling to put the sticky notes on. That's pretty slick, I have to say. And what you're doing is you're visualizing the various pieces that have to then be re-expressed,
because that's all come from what all those pieces are is this is one of my notebooks where I've just taken notes.
Right.
This is another one here where and this is like quite a bit of notes. This is after doing sessions or during doing sessions at usually civil firms or trial practice programs. So many ideas are flowing around and I'm like, oh, that's a thing. And then I write a note. But the thing is, there's no rhyme or reason. So I've had to go through this and go, now let's organize it into the ideas that had to do with conceiving the case story. Then there's the ones for organizing the case story and then presenting the case story. It's like separate components, you know?
Right. You're building, I mean, I'm not going to say you're building a movie, but in many ways you're building a movie. I mean, this is what people do that create movies. They storyboard the movie.
Yeah.
And then they refine it. And now, interestingly, I just acted as a judge at Stanford University. It was an AI contest. It was essentially a group of teams, 40 teams competing for best prize for the best AI-based app of the future. So these are projects. They're not final products. They're projects. But the interesting part of the class, it's actually CS 147, which is a Stanford computer science class run by James Landay, the professor there, who's run it for years, is they actually do it in a systematic way. So they have to conceive the idea they have in mind, which means they've got to go to the community and find out, well, what does the community need? What do people want? Now, of course, the members of the team have an interest. Some have an interest in music. Some have an interest in, doing stuff like community awareness raising. Some have interest in childcare and so on. So there's topics or themes But then the individual projects are all very different based on how they decide to approach a particular problem, and then how they decide to create the storyboard around the problem, and then the screens, and then the content, the video, the audio. And in many ways, you could say that's like the deposition transcripts, that's like the exhibits, that's like the simulation of an accident if you have an accident case, right? It's all those things that represents digital assets now, because all this stuff gets digitized. Years ago, it was just be paper, right? I mean, we're focusing on damages because the topic that came up, which is of interest, is lots of lawyers, and I've seen this for decades, they don't really focus on damages, and they don't conceive or think about a case around damages. The better personal injury lawyers are totally about damages. The better personal injury lawyers, they live and die for trying to get the best damage case. Usually they have cases where liability is pretty clear, and the whole case is about damages. Like, there's going to be a finding of liability. Sometimes liability is even stipulated to, and you'll hear lawyers say, don't stipulate, because then the jury doesn't get to hear a lot of the gory stuff that has to do with the liability. And there are defense lawyers that'll sometimes stipulate to liability, and they'll focus the entire case on damages. And that's a separate strategic question, but you're the master of storytelling. So tell me, just generally, when you have a plaintiff, because you represent both plaintiffs, or you have helped both plaintiffs counsel as well as defense counsel, I don't think you ever work directly with plaintiffs individually who want to represent themselves, right?
No,
you don't do that.
I haven't. No, and no one's going to have money too. So no.
Yeah, that's a rare event. But nowadays, there are a lot of people that want to represent themselves. So in theory, you could open up your practice to, I'll help you. But you really want to represent yourself? I mean, there are people like that want to defend themselves.
But I mean, much more, of course, that's very, very unusual. And the problem that is faced by, I mean, it's like the whole storytelling problem happens on the damages, which is like, how do you make these numbers that are unrelated to anything and just are numbers floating in space have some kind of basis in reality? And there's a number of ways to do that, of course, but it really this is an example I've just started to use. It's perfect for this. It's actually from defense side, though, that I just started to use. It comes from a real case at an insurance company where I was working with somebody here, and you could present the reason that you're not going to pay from defense. You're not going to pay Mr. Graham's damages. You could present it as just a bunch of numbers, and you say, we accept liability. So like you're saying, Jack, we accept liability for Mr. Graham's back and neck injuries, the direct result of this automobile accident. We'll pay the medical expenses associated with those injuries, but we reject his injuries because he went against the instructions of Dr. Fry, and so they're claiming $1.2 million. We are going to supply $18,346,000 for the, whatever. And then you can go through like this amount of numbers plus this amount of numbers plus this amount of numbers equals the correct number we are going to pay, which is $42,238. And the whole jury's going, okay, what? I don't have anything to anchor this to. Why would this matter? And why should he not get the 1.2? The story version of it goes, Mr. Graham is a competitive weightlifter, and his event is deadlifting. That's where you lift the weight off the floor up to your waist. Well, he's in an automobile accident with my client, which we've claimed liability for, and we're going to pay for those injuries. He starts to go to the doctor. The doctor says, don't go back to weightlifting, which he doesn't do for a while, but then he takes a shortcut because he wants to get to his competition in the fall. So he starts going back to lifting the bar from off the floor to up to his waist. We're going to pay for the time before he took a shortcut. So that's a very quick example of the same thing being told in numbers versus told in a story, kind of really loosely here for this, but that's the difference.
It's huge. That's a huge difference. as human beings, we understand story. We've been hearing stories since the time of the cave person, used to be caveman, but cave people. And stories allow us to anchor, as you said, our understanding of what actually happened and what's justifiable and what's fair and what's reasonable. When you present it like it's some sort of set of numbers on a spreadsheet, doesn't have any meaning at all. Zero.
No. And the way it gets that way, this is the territory I'm in all the time. The reason it gets that way by the time the jury hears it is because the lawyer or the team of lawyers is so familiar with the story. They're so familiar with what happened and why it matters that they're trying to simplify it by zeroing it in on just the numbers. So they think they're doing the jury a service.
They don't get it.
They always forget the jury does not have the benefit of your comprehension of the context necessarily. And sometimes they need it repeated more than once so that they're paying attention only to where there is an error. A human being did something wrong. And that's what they're willing to pay for or not pay for, depending on what side you're on,
Right. And we have a recent example. I'm sure someone's going to make a great movie about this Sam Bankman-Fried criminal case.
Yeah.
I mean, I don't think the defense had a single story to tell. I don't even think they even tried. No. I don't think they even tried to contextualize the way this guy operates, the way this guy was thinking about life. I just don't think they even attempted. And I don't know. I've only clued into the summary version. I haven't read the transcript. I obviously wasn't there. In my heart of hearts, if I had to live another life, I would be sitting there just listening like the jury as a shadow juror and saying, holy shit, why are they not showing this guy to be what he is, which is he's kind of a very special bird in the very extreme sense of having a mindset that's very different than most individuals. I don't think, frankly, this is my 2 cents, I don't think he's as culpable as the jury found him. But man, did they slaughter him. And I think the judge is going to slaughter him now. I think the judge is going to totally, I predicted he's going to get north of 25 years. The guy is only 31 years old, maybe 32 years old at this point.
I think that case had such an intuitive wrongdoing. I'm always, whenever I work on cases, what's the intuitive hook? Before you have to get into explaining anything, what just seems wrong? And in that case, you got a guy who's a big egomaniac that thinks he's going to game the system, going into a system that is full of fake money. And then he makes a bunch of fake money for his fake company.
No, but actually he did game the system and he did make a lot of real money that did add up to what was recognized to be, a $8 billion or $40 billion company in 4 years.
Well, that's what I mean is he made fake wealth out of real money. Like he didn't deserve any of that. And the thing is that the defense didn't have a leg to stand on anyway, but it's even if they had, they would have been up. And I've worked on these cases. You have a leg to stand on, but you're up against something that's so intuitively wrong.
Yes.
That the jury can't get past it. They're just like, no, that guy did wrong. I don't care what you have to say. That guy did wrong.
I was curious because we're talking about damages and that was a criminal case, but it did have an important element of they needed to show real harm. They couldn't show this hypothetical up in the air, somebody was injured here. So the first witness they called, and this is what made me think of this case, is they called someone who said, I lost $100,000. And it didn't sound like a big amount of money to me relative to the amount of years of this guy would go to jail. But they convinced the jury that he was just one of tens of thousands of investors that lost six-figure money. And that got across within the first day of that testimony. And I don't think the defense was ever able to address that in any meaningful way. So it led me to wonder, well, what would David Mann being tasked by the defense and being paid a huge amount say, well, what do we do? How do we contextualize this? How do we imagine fixing this problem where there's so many innocent investors who have lost money, and also innocent customers too, because same problem, right?
I don't know. I have no idea. Although I suppose if I were to take a stab just initially, the territory you'd be in for defense on that case would be in the territory of all of those investors knew they were investing in something risky. I mean, now that's not the story altogether, but that it would be in there somewhere that you'd find. Okay, I mean, the thing is that somebody said this at a seminar I was at, and I'm totally like adopting this from now on. Juries will hook into where someone had not the way that this presenter said it was knowledge plus control equals blame. Whoever they perceive as having the knowledge and the control to avoid the outcome that we're here in dispute in trial to talk about, that's who gets the blame.
Right. The example, just for listeners who are not lawyers, is if you know or have reason to know that there's ice in your driveway and you have control over the ice by putting salt down, scraping it, running hot water, whatever, that knowledge with that control is going to put you in the position of being negligent or suffering blame. Even if you say, well, you're the idiot that didn't wear the right shoes when you were climbing up the driveway to deliver the FedEx envelope or something, right?
Yeah, I mean, that's a good, your basic slip and fall. I mean, that you could have, that's 50-50, like depending on who tells the better story, because you could, plaintiff could come along and say, or our defense could come along and say, well, you were looking right at an icy sidewalk and the light was reflecting off it. It was very clear that it was. There were also, this would be key, there also was another path through the snow that you could have taken that you wouldn't have slipped on, ended up at my door. So it's you chose that path, the risky path. Too bad.
I brought that one up because I know we're in December and you're in Minnesota, right? You're in Minnesota. It must be snowing there by now, is it?
Well, no, it's a little bit, but the past few days we've had that frustrating, like icy, like it's been a total nightmare to drive because the roads appear to be the same as when they're not icy. And so everybody's losing their minds and slipping all over the place, even when you have 4-wheel drive like I do.
Yeah. I mean, I do think there's so many examples, and I think judges do operate from that exact position of knowledge plus control. Yeah. And this guy, Sam Bankman-Fried, also goes by SBF. Seems like everyone that's got a 3-letter acronym these days is guilty as charged, Like you can almost go down a list of anyone with a 3-letter acronym for a name. But conceptually, he did not really, but he came close. They tried to do something that said, well, he thought all of these investors and customers were in this speculative hedged pool of money, and that the money that was being floated back from FTX, the platform, back to the Alameda research, trading firm, that was all part of a hedged kind of speculative pool of money where everyone was borrowing from each other, and so everyone was subject to the same risk of loss. But that didn't match the facts. I mean, that's a nice theory, but the facts have to match it, right?
Where's the evidence of that? So great. That sounds like a great story. But where was the documents they signed that said, I know that I am entering into a totally,
Right. Into a margin account. That's called a margin account, where you're borrowing money and everyone's borrowing from each other. But that wasn't the facts. And I think to myself, and knowledge and control, his dad, SBF's dad, was a professor, or still is a professor at Stanford, and was a consultant for the company, being paid a consulting fee. He could have probably imagined this problem and addressed it had it been brought to his attention. So, of course, everyone's wondering, his mom is also a professor at Stanford, also a law professor. Both of them are. Yeah. They had some knowledge. I don't know if they had control. I don't know if they could have had control. Parents give up control probably when a kid is 16 these days, 18 from the point of view of adulthood. But,
Yeah.
to some degree, if they're involved in the actual business and they can see things and they're not doing anything to, straighten things out, it looks almost like that knowledge and control
Yeah.
theory generates blame for them, which of course there have been a lot of articles written about it as well.
It's also too, I think, where storytelling and damages kind of come together. Just this case that I was just talking about on this big long call. Of course, I can't say anything about what it is,
Yeah, of
but
course.
but it's a pretty classic, like two people who started a company together, then split, and one's blaming the other, they're blaming each other, and it comes down to who gets the correct share of the pie,
Right.
So we're talking about many, many, many millions of dollars. And so the risk with this kind of thing is for a jury to be like, oh my God, it's the clash of the titans. I can't relate. Who cares? They're all millionaires anyway. They're going to be fine.
Right.
And, should it be 20 million or should it be 60 million? And every juror is like, so the story has to focus not so much on the dollars or even like the share of the pie so much as it's like who was cheated out of something that they rightfully should have had. That's one of the most primal human instincts, is like, I don't want someone else getting something that belongs to me.
Right.
And you look at another person getting something that they shouldn't have, that belongs to someone else. There's an urge that we say, no, stop that.
Right.
You look at the way politics are, especially on one side of the spectrum here, they're very, 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 they have a hair trigger for that stuff. Someone getting something they don't deserve.
Right.
So I go, that's where you want your story to focus, is that territory, and kind of like leave the numbers a little bit off the table for quite a while till you have to.
So when you have a case and you're representing a plaintiff, or you're helping a plaintiff or a plaintiff's lawyer to maximize damages, of course, the lawyers want to think, hey, let's focus on the numbers. Let's focus on the spreadsheet. Let's focus on the expert testimony. And you're trying to bring story in, and you're trying to say, the anchor's got to be there before anyone's going to do anything super favorable.
Yeah.
How do you just generally go about trying to tease out how you get the anchor set? Like when you look at examples that you've had in the past, because you've done many cases, and you're not a lawyer, but you might as well have been, because you're better at this. You're better at this than
the lawyers are.
Most other lawyers, because you take a step back, and lots of other trial jury consultants are out there, and trial theorists, and trial science. They're now called trial science. And I'm just kind of curious, how do you go about just generally? I know you absorb a lot of information, but what's your approach
to getting the lawyer to focus in the right place?
Yeah.
Well, it depends how receptive they are to stuff like this, but I like to keep coming back to them and saying, if the jury doesn't understand it, and if it doesn't resonate with them, we have to try again. We have to keep trying approaches that we can reasonably expect to resonate as well as be understood intellectually. It's got to feel right as well as sort of be mathematically right. And keep going back to the simple story of basic wrongdoing, and then try and work out the internal stories. So there's the macro story of what happened, but there's also like the little story of, on one of them I worked on a long time ago now is a guy falling like 20 feet onto his head, and then his shoulder, and then his arm all went ka-boom, like, real quick.
Right.
Rather than saying, well, this guy's injuries are $3.5 million over the, I worked out a thing where it was like a slow motion description of his fall, and just went, okay, his head hit. That resulted in the loss of these functions and this and blah, 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 and that's a lot of trips to the doctor. No numbers yet.
Right.
His shoulder hit, and that has caused him to have no use of this, which means he can't go fishing with his kids and blah, 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 whatever. And so you kind of like make each little piece of the injury into its own mini story with these life repercussions. And it's easier then for a jury to say, oh, yeah, I think I understand how to assign these damages at the end. Thrown at them as a big lump sum for medical, then it's much, much more risky, you know?
Right. So you decompose it. You're really good at decomposing what might be called the episodes, or might be called the mini scenes, right? Because you're decomposing it in a way that hopefully gets across that the impact or the overall injury or the overall damage, even if it's just part of one damage case, justifies a much larger number. And the flip side is, if you're defending, I imagine you do the same sort of decomposition around to what extent was there contributory fault or comparative fault or assumption of risk or whatever other defenses are being asserted.
Yeah, I mean, it's on defense side, you're usually aiming for, zero. I mean, if unless liability is admitted and everything already, but if it isn't, and you're aiming for like, nope, you've got the wrong guy here. It's that somebody is definitely to blame for that person's injuries, but it's not us.
Right.
And then you got to tell all of that story and just get it off of you, which is of course easier said than done. And maybe you have to throw somebody else under the bus if there's a way to do that. Or you just divert it off yourself to like, we don't know who's responsible, but there's what I always kind of like to throw out to the lawyers is there is the Uber story that we're telling that has to be clear and simple. But inside that, there are the little stories of each piece of what happened and why it matters. I mean, how does a financial scheme result in, like, I worked on this huge securities fraud case, the Petrobras scandal, about 7 years ago, and that was aiming for an $80 billion verdict is what we were aiming for. $80 billion verdict.
Wow. It
ended up settling for $3 billion. But in order to get the focus group jury even to understand what was going on, we had to break that this mess of a financial scandal down into like a really, really simple explanation of like one example case of how $20 million would have gotten diverted to the wrong direction out of $100 million refinery build. And we're able to do that in like 2 minutes, and kind of like your thing, like your $100,000 guy, then multiply that by the amount of refineries that were built, and you have a pretty big scandal.
Right. So when you get these cases and they're big cases, you have to absorb a lot of information. I imagine like there's a huge knowledge transfer process that has to occur from the law firm or the lawyer or the lead lawyer to you individually, right? That takes some time. Now, I know you're a quick study, but don't you have to have hundreds of hours? Because the lawyers typically have hundreds of hours in this stuff.
Well, when you charge by the hour or charge by the project fee, you have to get them to agree that they're going that me putting in that kind of time is going to be worthwhile, which when I'm 3 or 4 cases down the road with a firm, then they understand it. But the first one, it's hard to say, hey, I think this is going to take 100 hours. You go, I'm going to have to do this in a very short amount of hours to prove the value. Okay.
Right.
So that's where I've had to train myself to what do I really need to look for in all of this material, and what can I completely ignore? It's not going to have any bearing on what I'm doing with them.
Right.
So that's what I've kind of learned how to do a little better.
So you're a pretty fast study. I know that. And I imagine you're now seeing many more people want to test ideas against focus groups, right? Which these days are being done online on Zoom.
Yeah.
And, the old day of two-way mirrors and all that jazz, people are like, that I don't think people are doing that anymore. There used to be office buildings in San Francisco. That's all they had were two-way mirrors and focus groups that were being called in. And then the pandemic happened and people weren't going to the office and they weren't going to go to an office building for a focus group meeting.
If
So
it's still, I've done a couple just in the last year, and so they're still happening if the case is big enough. It just becomes down, it comes down to like it has to be a massive case
right,
and to put in that kind of
money,
resources into it.
right.
Yeah.
Because I think the quotes I get for focus groups all the time, which I think are, high, but they are what they are, is $50 to $100,000. And I often say,
easily.
yeah, I often say stuff like, are we getting a $50 to $100,000 worth of value? And maybe in a very large case, you'd say, yes, you are. But in a smaller case, I've run some focus groups which have been done online, and you get some really interesting information that you hadn't necessarily thought about, which I think is the best aspect of a focus group. Now, obviously, you can say, well, that's more of a brainstorming group than a focus group, because a focus group, they should vote. And then you should be paying attention to what the hell the vote is saying about the demographics of that jury.
Well, what's really, I mean, it's usually defense firms, I think, that are going to cough up the money for these things, because it can easily be $100,000. But if it's going to help them avoid paying $100 million,
great investment.
They're going to do it, and you're going to have, in the ones that I've seen, you will usually have like 3 juries in one focus group, and they're going to go to 3 separate one-way glass rooms. What I have always found to be utterly fascinating / a little disturbing, they are operating with what they consider to be 100% of the information. But you are watching it going, you guys have about 36% of the information. You just didn't understand the other part.
Right.
But you're operating with what you consider to be all the information. And then they make this big decision about whether $100 million goes away or not, So it's
right. It's a version, like I like to say to clients, the jury and the judge is getting a version of the facts, which is highly abstracted from what might be called the full Tolstoy 600-page book. They're getting like the film version, maybe even the TV show version. They're not getting the level of detail with all the footnotes. And they, even if you tried to get them to read that and understand that, they wouldn't absorb it. They're getting kind of the playwright version of it. And if that playwright version works, as it did really well for the United States against SBF in New York City just a couple of months ago, a jury will, and a judge will respond to that. And if it doesn't go in the right way, if it doesn't land, as you like to say, because testing whether a point really lands, matters. And, at the detail level, what you do, a big part of what you do, which is so important, is you make the simple message, that's the name of your firm, make the point that matters and figure out what is that point that really is going to matter.
It's the point, and it's the proportion of, because you're going to make more than one point. You're going to have to cover a lot of stuff. I try to look for like a simple core message that runs through all of it, or a theme, but you're usually going to have to make multiple points. And where cases fall apart, in my opinion, in having working on this so much, is lawyers will understand all the stuff they need to say, and they may even be able to boil things down to a pretty simple message. But then they go out there and they spend way too much time on this part, so that by the time we get to this part, the jury is fatigued, and then we get to this other part and they're really fatigued, and they haven't like factored in that people have a time allotment for paying attention. My classic example is a trial practice program I was a part of for a huge global firm last spring. And these young lawyers are doing cross-examinations on a contract case. And I'm watching them do 45 minutes on one sort of paragraph of this contract. And I'm watching the jury that we brought in, because it was basically a mock jury, falling asleep. They cannot possibly track. It's way too abstract. So the question becomes, then why are you talking about it? Why are you talking about it? Like, if they're not getting it, who cares? They have all the power,
Right, right. A lot of lawyers make the mistake of thinking somehow the record on appeal is pretty important, but that the record on appeal allows them to bore the jury, because if they don't do that, then eventually they're going to suffer some risk on appeal. Unfortunately, they may lose the case. And they don't understand that in most cases, the appellate court's going to say the jury just didn't believe your client. That's why the jury went against you. And it's game over. The appellate court is not going to reverse something if they think the jury, within its discretion, did something within the bounds of the law. And even so in many ways, they kill their own point.
Yeah, you can. I always believe that even if you are aiming for the record, and it's sort of a dual audience, there's always a way to simplify it. If you just do the work to go in and go, do I really need to say all 18 of these things, or can I say 5 of them and get just as much impact? And that's usually possible to do. And you're going to get more impact,
But I'm kind of curious, maybe my final question is, when you deal with mock juries and they come back after you've simplified it, and you do a great job of simplifying, and they come back confused, like, what do you say to yourself? Do you say, well, wait a minute, I missed a real important point here? Because it must happen, right? That you take a case that's really noisy and you think you've simplified it, and then it turns out you didn't simplify it enough.
Well, usually they're not going to know they were confused. I mean, they will give you feedback that will tell you, oh, this is a section they didn't understand correctly. And then you go, okay, well, next time around, we're going to clarify that section. Or I can be surprised at where a thematic thing will resonate, and from the other side, and I was like, oh my God, I thought for sure this theme was going to be what they're going to, and that's just, I'm learning too, about human nature.
Right. I mean, at the end of the day, if you have the budget, doing multiple mock trials probably is like the ideal world. And I can't even imagine that the SBF case had enough time to even do a single mock trial. Plus, the guy was in jail, so he couldn't even do a mock trial.
Yeah, right.
Because he kind of threw himself in jail by writing a bunch of stupid emails that upset the judge. Like, he put the noose around his own neck, because had he been out, on the bond that his parents posted, a pretty big bond, he could have participated in a mock trial, and they probably would have said, the jurors don't like you, you can't testify. And he decided to testify, which probably screwed him not only with that jury, but I think with the judge. The judge didn't believe he was telling, I believe the judge didn't believe he was telling the truth based on the remarks I read in the newspaper that the judge made, in which case that's going to affect sentencing. So it's like the ultimate damage for him is he might get an extra 5 or 10 years of time behind bars as a result of this.
For being unlikable.
Tell people how they can reach you, because you're a marvelous person and I highly recommend you.
Go to my website, asimplemessage.com. Asimplemessage.com.
Easy to get to. It's a great website too. You got a lot of video content. And what's your phone number when people want to reach you that way?
612-756-0200.
Great talking to you, Dave. Take care. Be well.
Right.
Have a happy holiday.
Tune in next time on The Valley Current.